Yes, Pradyumna, you can start.
Good evening, one and all present here. The meteoric rise of technology over the recent decades has gradually posed immense technological and techno-legal challenges in the world. Technological advancement, which is only a facet of the dynamics of social change, has necessitated a legal system to adopt and embrace such technical phenomena so that order and harmony are preserved, and more particularly, the commerce and industry are augmented with full legal sanction. The advent of internet, a network of network using open standards of information technology, has given rise to a digital revolution, emerging as a key enabler and a critical determinant of nations' growth and well-being. The emergence of cybercrime and the growing tentacles of cybercriminals in cyberspace has sparked a global pitfall in the technological regime, causing concern to the government, banks, organizations, institutions, and individuals. Therefore, the requirement of a comprehensive cyberspace legal regime to regulate such challenges is the need of the hour. It is the pleasure of our institution to host a webinar series on intellectual property law. Yesterday, we had the second session on trademark law titled A Primer to Trademark Law and World Intellectual Property Organization. And today, we have a third and last session titled An Insight into Cyber Intellectual Property Law. To educate on this topic, we have Dr. Tripura V, Assistant Professor, esteemed faculty member of PS University, Faculty of Law. It is my pleasure to welcome the learned speaker, faculty members, and participants. Before we start the session, I feel happy to present a brief profile of the resource person. Dr. Tripura V has completed her BA LLB, securing fourth rank at University Law College, Bangalore University. Obtained her LLM, specializing in intellectual property and technology law, bagging second rank at National Law University, Jodhpur. She has been awarded PhD for her research thesis on the topic is socio-legal study of protection of farmers' rights and plants varieties with special reference to southern districts of Karnataka by Bangalore University. She has also published and presented various research papers in reputed journals and conferences. She has a vast experience of serving prestigious legal institutions and academies, currently serving as assistant professor at PES University, Faculty of Law. With this brief profile of today's resource person, I extend a warm welcome to one and all here. Over to you, Professor.
I think that was the invocation song as well. Thank you very much for that warm address. To begin, as you have already got to know that I am a faculty of law, and also my specialization is with respect to intellectual property law. I've been hearing that this is the last session. I know that the last session will be the most boring session ever, but I hope that I'll try to make it interesting as far as possible. And in fact, although this is the last session or the session which generally people do not want to know, even in fact, I also feel the same thing whenever it's the last session, last hour of the day. I don't want to do anything, but still, I think the topic here we'll be discussing is something that is a very important and an eminent topic for the future. There is no future without intellectual property law. There is no future without cyber law. This is going to be the future, and therefore it is important and also a necessary step for us to understand the nuances of these two different areas. Thank you, Vivekananda Law College, for providing this opportunity to impart a bit of knowledge that I have to the students of law. Hope these are students of law only. And I also see my seniors and teachers here. Hi to everybody. And to begin with, I would like to share my PPT. It is not that interesting or creative, but still it has a lot of information. Is this visible for you?
Yes, Tripura, it's visible.
Yes. All right. So now let us understand a very unique intersection of two different aspects of law. One, it is the cyber law. On other hand, we will be discussing about intellectual property law. And the very important aspect that you should understand here is the intersection between these two. Yes, I can study cyber law for a semester without touching upon intellectual property law. I can also study intellectual property law for an entire semester or even get a master degree in that without looking into cyber law. But there is a very beautiful interconnection between how cyber law is interconnected to intellectual property law. And that is what we will be discussing today in this session. I'll try to make it very simple and also quick so that you have an effective session where you have a bit of information which is sufficient for you. Yeah, to begin with, uh, the story goes like this. How did we actually started having internet? How did it all happen is the question. This began somewhere in 1960s when people were trying to send information from one device to another device. The idea of computer itself is very new compared to any other invention of the mankind. But whatever the content that was created on the computer to be transferred to another computer or to be transferred to another location was a bit difficult for the researchers back then. That is when the idea of internet emerged in 1960s. And also during the Cold War, that people wanted to have a effective communication medium, even in case of probably an attack. For example, during the Cold War, Russia did launch a satellite called Sputnik. So even after the attack, they wanted a medium so that it is safe from all the attacks, so that there is efficient communication that won't happen. And that's the reason why there was an system that was established that's called as Advanced Research Project Agency Network, which was eventually called as Internet. So ARPANET, now we call that as Internet. This is how initially the idea of Internet popped up. And whatever we talk in fact with respect to IP address, you could see that 192 dot dot 68 dot dot. So now what is this IP address? It is identifying where the particular computer is. So this IP address was established somewhere in 1983, and we actually celebrate it as the birthday of internet. So that was the kind strange information that I wanted to share it with you. In 1983, that is January 1st, 1983, is celebrated as the birthday of internet. So although it is an evolving nature in the sense it started in 1960s, but it is continuing till date. It is evolving in nature, and every day we see lot of understanding, lot of new things that are popping up with respect to internet. Whenever we hear the word internet, something that strikes to our mind is Google. So we only know Google. So whatever the information that we want, we'll just search on Google. But internet is not synonymous with Google. Google is one area of internet or one server, one service provider of internet, which we are all fond of. That is the only thing that you should be having in your mind. So apart from that, recent trends in internet include Internet of Things, artificial intelligence. What is this Internet of Things? For example, I am at my workplace. I have to switch on probably a washing machine. I can do that sitting right in front of my office desk. I don't have to come back home, turn on the machine and do things. I can do it through the help of app. And these days you might have seen about the robo vacuum cleaner or the AI powered kitchen appliances where you don't have to necessarily be there to operate them. So these are the things that are in style, in vogue in the present times. So I'm sure all of you are aware about in artificial intelligence, how it is influencing our lives. Right from you heard of the stories of the automobile industry being driven by artificial intelligence. For example, Tesla, you don't require a driver to drive that car at all, and everything happens with the help of internet and technology. That is the trend, and that's the reason why I told you that this will be our future. Artificial intelligence, intellectual property, cyber law will be our future, and therefore it is very important to understand the interface between all of this. Hope I'm audible enough to you, and there is no doubt about it. And another thing is, am I going a little fast?
No,
No, no,
madam, you're perfect.
All right. Thank you very much. We will proceed further. The next topic for my discussion. So you have understood how internet was evolved and what is the status right now. So this is a very brief outline of how it actually happened. There's a lot of hypothesis with respect to how exactly internet came into picture. Let's not worry about it too much, but this is the basic understanding of the evolution of internet. So moving further, we will understand the idea of cyber crimes under cyber law. First, let us understand what is cyber crime. See, as I've told you that earlier, because of internet, the things have been very easy for the mankind. We've been able to deal with many of our day-to-day activities at ease because of internet, because of technology, because of computer devices, all of this, isn't it? And whenever we talk about some kind of boon like this, there is always a bane. So that is what we are going to discuss. Yes, technology is always handy. At the same time, it has also allowed individuals to carry out crimes that are not good for the society. And these crimes are committed without allowing anybody to know their identity. Anonymous nature of the commission of crime is one important aspect that we will have to deal with. So that is the major drawback of the internet technology that we generally discuss about. Now, we've been using this word cyber with respect to cyber crimes, with respect to cyber laws. We also talk with respect to cyberspace, and by and large, we try to use this word for everything. In fact, what is it called? Cyber hubs, also called as cyber centers that were there back long ago. I'm sure they are still there, but still not as much as they were there almost 10 years ago. So, what does this particular word cyber mean? So, general dictionary meaning of cyber is relating to or involving computers or computer networks. This is the general meaning that we will get while we search on Google. So, that's how we have been used to searching things. So, this is a definition that we have. So, what is it saying? It is something that is relating to or which involves computers or computer networks. See, they are very clearly specifying, they are very clearly telling us that it is not just internet or it is not just computer devices. It is computer devices or internet devices. So anything that is associated to computer can also be called as cyber devices or cyber technology, and anything that is associated to internet can also be called in the name of cyber. So this is the prefix that we use to describe anything related to computer and the information age. Hope this is clear for you.
Yes, madam.
Yes, madam.
Okay. So generally, in a common man's language or in a layman's language, we can actually call cybercrime as a computer crime. Any crime committed with the help of computer and its related devices can be called as computer crime, also called as cybercrime. And you know that there is no exact definition as such. Every individual wants to define cybercrime in a different way, and I wanted to put it in a very simple word so that it remains in your memory. So cybercrime is any criminal activity that involves a computer, network device, or a network. So any criminal activity. Now, what is criminal activity is again very subjective. It depends on case to case basis. We will understand a bit later. Now that we have understood what is crime or cybercrime, let us understand the different types of cyber crimes that we know. See, whatever I've mentioned is just a few of them. There is n number of crimes that is evolving every day, which is related to cyberspace. See, the space wherein we discuss about or where we deal about cyber technology, crimes, or any of those laws is called as cyberspace. So in cyberspace, every day there is an advent of new type of technology, which is could be a positive one, could be a negative one, could be something that is not good for the society, something that is good for the society. So now let us understand what is not good for the society and what is called as cybercrime. These are some of them that I mentioned. You might have generally heard of hacking. This is the first thing that we generally say or use this word as in when we want to talk about unauthorized use. So now what is hacking? Hacking talks about uh, the unauthorized use or access from by one individual to another individual's account. It could be on a different computer device, or it could be any social networking account, or it could be your email account also. If XYZ person, without access to, without getting permission from ABC, uses or gets the control over his online content or his computer, we call it as hacking. It's a very simple understanding. Now, then the next important one is the identity theft. This is the most happening one. You might have heard of these stories where celebrities or a politician put up their, tweets and their status saying that their accounts have been hacked, or someone is impersonating another person and asking for money or asking for some kind of help. This is called as identity theft. It is also called as email spoofing. Don't worry about that, but understand what is identity theft. Let's say somebody calls you tomorrow, says that she is Dr. Tripura, and asks you to transfer money immediately because there is some urgency and my other accounts are not working. So you believe because of the identity that I'm expressing, and you try to do the transfer. At times you might have also seen, heard of the stories where people call and ask for your details, saying that you have won some award and other things. So what are they trying to do? They're trying to impersonate another person. So that is called as identity theft. The identity of a person is being stolen by another person who is not genuine. So that is called as identity theft. The next one is the virus attack. This is at times this might happen purposefully, and at times it might happen accidentally also. You might download some kind of software or some app on your phone or your devices, and through that mechanism there will be a kind of virus, just like biological viruses that we have seen so far with the advent of COVID and other things. Similarly, these viruses include, for example, Trojan horse. So they enter the computer, and the capability of this virus is self-replicating. That is what happens in case of the biological viruses also. What happens in biological virus? When the virus enters the body, human body, it starts to multiply, and when it multiplies, the number of the virus is so huge, and it is ever multiplying. It can damage the entire organ, entire immune system. Exactly the same this happens with respect to the virus attack in terms of computer and any other electronic devices. Once the virus, like it is also called as like, for example, Trojan horse and malwares and other things, once they enter into the computer system, they start multiplying and they will destroy the data that is there in the computer. This generally happens where huge data is saved in a computer server. Purposefully, people might also want to destroy the server, and this is generally that we would hear now and then. So this is virus attack. We also have cyber terrorism. It is nothing but terrorism. That creating haste among the society members so that they revolt against the administration and also the government. That's the mechanism which happens with the help of computer technology and other things, is called as cyber terrorism. Whatever we have understood so far with respect to the terrorist activities, they generally are planned not physically, at times mostly virtually, because they know it is easy for them to communicate and nobody can understand where the person or the organization is. All of these are the advantages of having cyber systems. So therefore it is called as cyber terrorism. Now there is something called as phishing. It is not the phishing, it is phishing, or you can call it as phishing only. So what exactly happens uh, with respect to phishing? It is almost similar to identity theft, but here, if a user, he is being tricked, saying or making him believe that the process is genuine, that is called as phishing. So this can be better illustrated with example of, for example, you might have heard of the stories where the person got a call from a bank where his details were taken, and he was made to believe that it was a genuine call from his account, or the bank where his account is held. So another thing happens, and he would give all the details knowingly or unknowingly, and immediately the money is transferred from his account. So tracing those kind of activities is very difficult because of the huge network of computers. So it is very difficult, and that's what we call that as phishing. You might have heard of the word stalking, where a person, without the permission of another person, constantly, annoyingly tries to contact or follow the person, we call that as stalking. When the same idea applies over internet, for example, somebody whom you do not know or somebody you don't want to get connected with keeps on trying to contact you over your social networking site, or keep sending you messages which you don't want to see or which you don't want to deal with it, and this is called as cyber stalking. If somebody is annoying you with their movement towards you, which is not required, we call that as cyber stalking. And cyberbullying, this is again a very emotional kind of attack made by the user. So basically bullying is where people try to tease or harass the person. So if this happens over internet or sending messages or memes or converting morphing of the images, this is called as cyberbullying. So other than this, there are many other, for example, cyber crimes, including cyber squatting, cyber warfare. So I just wanted to tell you that these are some of the important cyber crimes that we all know. So hope this is clear. Going further, now, do we really have cyber laws in India? Yes, we do have cyber laws because of our commitment to UNICITRAL. We enacted cyber law in 2000. Although we say that this is the new law, it's been almost 23 years. So I don't think it's new any further. But anyways, compared to the draconian laws that we have, this is something really new. But believe me, nowhere in the Information Technology Act, in further I'll be calling it as IT Act, cyber crime has been defined. So we don't find an exact definition with respect to what cybercrime is. Whatever the definition that I gave, or anywhere you see, it is just the understanding of every person's understanding with respect to cybercrime. Hope this is clear for you. Now you've been heard of why do we require IT Act and other things. The major reason why we have is to recognize e-commerce. What is e-commerce? Any trading that is done with the help of computer, internet technology, and anything. Like for example, you're dealing, buying goods on internet through any of those applications, including Amazon, Flipkart. All of this will come under electronic commerce, and it also includes e-contracts, where I can sit here today and sign the contract with someone else who is sitting in America. That is still recognized. So the main purpose is to recognize the activities of e-commerce and also e-contracts. Apart from that, the Act actually deals with the recognition of electronic documents. And information technology not only directly deals with cyber law, cyber crimes, it majorly accommodates any of those newer things that we see in day-to-day life. For example, it could be your electronic evidence or the documents that are stored in your computer. Can they be used as electron? These are the things the IT Act will deal about. IT Act talks about what are these offenses. It talks about the recognition of certain criteria like your digital signatures and also documents and other things. Then most important, it talks about the offenses and the punishment. So this is the exact idea of Information Technology Act. Now, we will come back to another correlation between IT Act and IP later on. But for now, please understand what is the law that is there in India with respect to cyber law in IT Act. In fact, cyber law itself is demanding a new legislation, a kind of sui generis legislation, wherein the entire law only talks about cyber law and nothing else. Information Technology Act cannot stand in those shoes. So generally, when we discuss or when there is debate as to IT Act is sufficient for cyber crimes or cyber law, no, it is not at all sufficient, and therefore people are striving to have a new law on cyber law, especially. Let's see what will happen in the near future. Moving further, okay, this is the most interesting domain for myself, and also I'm sure this will fascinate you as well. Now, all of this time we have understood what is cyber law, what is cyber crime, what are the different types of cyber crime, what is that law we have right now, what is the future of it. Now let's understand a different domain that's called as intellectual property. So I'm just talking about intellectual property. I'm not talking about law right now. So now what is this property? Property means an asset, so which has some value, where it can be owned and possessed, all of this. Similarly, intellectual property is also an asset which is intangible in nature and which provides certain rights by the government. Now, what is the subject matter of intellectual property? I've told you that it is a property, it is an asset which is intangible in nature. Now, let me stop there. Now, what does the word intangible mean? Please understand. If I can touch an object, if I can feel an object, if I can see an object, we call it as tangible asset. Let's say your phone. You can hold it, you can use it, you can throw it, you can do whatever with respect to that. That's a tangible asset. Now, when we talk about intellectual property, it is an asset which can't be sensed in a sense where your sense organs cannot feel it, but it exists. That is the very beautiful nature of intellectual property, and other components of ownership exist with respect to intellectual property also. Other component of possession is available with intellectual property also, and most importantly, economic value. Yes, it is equally valued when we compare it with the actual material property. So, hope you've understood what is intellectual property. Now, I have told you that it is an intangible asset. Now, what are those assets? That is the question. As I've already told you, just like our internet, which is evolving, intellectual property is also evolving. Every day, we are finding something new that we can put in the bracket of intellectual property. Some of the major subject matter of intellectual property include inventions, creations, or a brand value, logo, all of those things. We will discuss in detail a little later, but please understand this is the broad idea of intellectual property. Now, if a right is being accrued to an individual by virtue of the property that he created, we call that as intellectual property right. And the law which protects these intellectual property rights is called as intellectual property law. Generally, when we talk about intellectual property, we say that intellectual property is a bundle of rights. It means that it has many rights. Similarly, we have many aspects in it, many types of intellectual property. That is one important thing that I want to stress upon. Now, before we get into understanding what are these different types or different aspects of intellectual property, we will understand why do we have to protect them? What is the need to protect them? See, in the slide, you can see that there are 3 pointers, but believe me, it is the major 2 points that we'll have to understand. It is a two-pronged approach. First thing is whenever you give the protection or whenever a right is accrued to an individual for his creation or his invention, you are motivating the person, you are encouraging the person.
Tripura
A kind
madam,
of yes, ma'am.
sorry for the interruption. I
Hmm.
think there are two windows have opened from your side, so we cannot see the slides.
Two
There is a
windows.
slide window also is there,
Mm-hmm.
but we cannot see that properly.
I haven't opened anything else. What is the other window that you are seeing?
The other window is slide only. One, the window you are only say we can see you.
Okay.
The other
Uh,
window, yeah.
I'll just pause my video so that probably I think you might be able to see it. Okay.
Check once. Check once.
Okay. Ma'am, now can you see the
Yes, yes.
entire?
Now, yes, yes.
Oh,
Now we can see.
probably because I had switched on my video.
Yeah, yeah.
Anyways, I don't want
Thank
to.
you, madam. Sorry for the
This one,
interruption.
no problem. Yes. So I was telling you that the need for IP protection is two-pronged. Now, what are these two important reasons why we are protecting? First, as I've already told you, it is to encourage the creator. Probably an innovator, researcher has invested a lot of time, energy to create something. So, therefore, to recognize the time and effort of the person and also to motivate the researcher or somebody who is involved in it, that is the reason why we are providing IP, right? Second important right is the reason why we are protecting is intellectual property per se is a limited right in the sense it is limited for a very short period. It is not like the regular property. So let's say if I buy a house, it means that it is there till I die and it will pass on to my generations, the legal successors of mine, isn't it? But that is not the case with intellectual property. Intellectual property is a limited right in the sense, for example, if I'm talking about patents, it is limited for 20 years. After 20 years, the patent falls in the public domain, which allows anybody to use it. So this is the reason why we are providing patent protection, or sorry, we are providing the intellectual property protection. See, understand, if I don't incentivize or if I don't encourage the innovator, he will not innovate. Because what is the point in he innovating things? Okay, I am now giving him recognition. I am telling that yes, this is a person who has done this. I am applauding him. Now the next thing is, what is the benefit if I allow him to use his invention or creation? He will only make money. And what is the benefit for the society at large? So that's the reason why we have the idea of limited nature of protection. After the period of protection, the knowledge falls in the public domain. So what happens when the knowledge falls in the public domain? That any person can make use of it and actually create further inventions also, or use them so that it is economically available to the society at large, and we progress gradually. I'll give you a best example of a pharmaceutical drug. Let's say I am an inventor. I have invented a drug today, probably to cure diabetes. All right. So yeah, it's a very unique drug, and nobody has done it so far. Yeah, my invention is applauded. I've got patent protection now. Now I can use this patent. I can use this drug without somebody using it for the period of 20 years from the date of filing. Don't worry of the technicalities. Just understand that 20 years I can use it. After 20 years I can still use it, but I can also not allow or stop somebody from using it. So any, let's say my diabetes drug is so good that anybody with diabetes, if they take this drug, they'll get cured in a week. My
Earbud.
huh?
Earbud.
Pardon? Okay. So I was telling you that the drug that I have invented might cure the disease within a week. And for the lucrative nature of my drug, I will charge 1 lakh rupee per one tablet. Imagine how many of us can afford 1 lakh rupee for one tablet. It is not just, yes, probably you can afford or anybody can afford, but it is not the case with everyone. Everybody will have diabetes, and it is very common now. It's a very common lifestyle disease, you know. So if a poor person or anybody without in, that particular bracket cannot afford, how do they survive? So after 20 years at least, the knowledge will be in the public domain. So there will be multiple players. Today, I am the only person who is manufacturing drug. Tomorrow, there will be 10 players, like the generic manufacturers. They will manufacture the drug. So the cost, obviously, the supply will increase and automatically the price will come down. So this is one advantage. So people will have access to this medicine, and probably will eliminate diabetes in total in another 20 years. So that is the ultimate idea of providing intellectual property. And also it helps in further research. Probably my drug can be used by another person to develop another drug which can cure another kind of disease. So this is the reason why we want the knowledge to be in the public domain. If you don't allow this kind of setup, what will happen? The knowledge remains with the inventor only. So it will not come out. He'll be very secretive. He doesn't want to give the information to another person. Now, how is he giving the information? At the time of making the application for the patent, he would have mentioned everything related to his patent or his invention. That's how the knowledge will fall in the public domain. Hope you understood that. These are the important reasons why we'll have to protect intellectual property. Hope this is clear for you. So I have clearly mentioned that there's a beautiful interface or a kind of check and balance between the interest of an innovator and also public interest. Hope this is clear for you. Moving further, now let us understand the different aspects of intellectual property. So I'll be briefly talking about them. Yeah. So first thing is the patents. We might have heard of this word patents, and generally I've heard people using it in a wrong way. They would interchangeably use it to copyright, trademark, everything. But please understand, patent is a grant given by the government for an invention which is new, or also called as novel, which is non-obvious and which is of some use. So this is technicality. Don't worry about the technicality of novelty, non-obviousness, and industrial application. Just understand that if your invention is new, which was not there earlier, then the government will grant you what is called as patent. Okay. Now, what is the period of protection of patent? It is 20 years from the date of filing. So what happens after 20 years? The knowledge will fall in the public domain. Anybody interested can use the knowledge and start making it. What happens during the period of patent protection? Nobody apart from the person who is the owner of the patent or who is the holder of the patent and the person who has been authorized by the patent holder be allowed to use the patent. Only the patent holder and the persons authorized by the patent holder can only use it. Apart from that, nobody else can use it. So you understood what happens with a patent. Now, do we have any law to protect patent? Yes, we have what is called Indian Patents Act 1970, which is prevalent. Although we had many amendments later on, let's not worry about the amendments. But this is the primary law that we have for Indian patent. Primary law that we have for patent regime. Now, the second important area is the copyright. Earlier, when we started talking about what is intellectual property, people had two understandings. They were classified into two categories. One was called industrial property. Second one was called copyright. Imagine how important it was for to recognize copyright beyond what is called as industrial property. Later on, because of the European nations and because of many of the international conventions, they clubbed both of them, that is copyright and industrial property. When I say industrial property, I'm referring to patents, trademark, designs. Clubbed all of these together and then they started calling it as intellectual property. So please understand, copyright was one domain which was very important since times immemorial. Now, what exactly is copyright? So it means that a right is given to a creator with respect to his work. Now, what are these works? Works might include literary, artistic, dramatic, photographic, and other works. As I've already told you, these days the IP laws itself is evolving. We are recently seeing the rights with respect to broadcaster, rights with respect to performers, and other things. Now, what is literary work? For example, a book, a novel, a song, a poem will all come under what is called literary work. Artistic work, painting, drawing, sketching, whatever the person wants to do creatively with terms of their art is called as artistic work. Dramatic work include dance, drama, and whatever the theatrical performances that we talk about will all fall under dramatic work. So this is the main subject matter of copyright protection. Yes, we have a law to protect that, and it is called as Indian Copyright Act of 1957. You might see that these laws were passed as early as 1978. Although we have been accustomed to know about this very recently, but we were having this type of law by virtue. In fact, the first patent law that we saw was in 1911. That is during the British regime. Okay, so that advanced we were in terms of science and technology and other related aspects. So you understood about copyright. Now, what is the period of copyright protection? It is generally it varies from the content to another content or work to another work. Generally, it is life plus 60 years. That is, if I am the author, if I have written a book, the period of protection is until I die. Let's say I die at the age of 70. So 70 years plus the remaining 60 years, life plus 60 years. So that is the total period of protection of copyright. Now moving on to another important criteria or aspect of intellectual property, that is trademark. This is the most fascinating and most lucrative area of intellectual property. Whoever wants to be in the market wants to get popular. Okay, trademark is not just aspect of intellectual property; it is also an aspect of consumer protection law. Now, what does this trademark do? Trademark, by virtue of some colors, logo, brand name, and other things, will identify the good to a particular source. Let's say if you see a tick symbol, you generally refer it to Nike. And when you hear the word Nike, you are referring to brand which will sell good quality shoes, isn't it? So that's how trademark is very important, where we connect a particular product to its origin or to its source. And that is one idea of trademark. Secondly, this is with respect to the person who is owning the trademark. Now, with respect to consumer, let's say I want to buy a packet of milk. Let's say I want to buy Nandini milk. Now, because of the logo, because of the color combination, because of the style that it's been represented, I will go pick up Nandini only. Whether I am aware of the language, whether I can read right, it is immaterial. But the color combination and the font and style and setting of it will make me pick up right Nandini, isn't it? Let's say tomorrow there is another brand of milk which is called uh,
Dodla.
no. I'm just trying to have a synonymous word to Nandini. Samvedini or Mandini, something like that. Okay, but it looks very similar to Nandini, blue color packet and the cow and other things, the font style, everything is very similar. What happens is a person generally it is believed that the milk is consumed by every other individual, irrespective of their income levels, irrespective of their class, standard, everything. So let's say a laborer who does not know how to read and write wants to pick up Nandini, and he happens to put his hands over Mandini because of the context. So this is the reason why we protect trademarks. That's the reason why we want to stop that kind of violation that might happen to the consumer. So that is the very essence of trademark. And as I've already told you, what is the subject matter of protection? It protects, it is a graphical representation to protect the brand, logo, combinations of any of those things. And what is the period of protection? As I've already told you that intellectual property is a limited nature of property, but in trademark, when you have a registered trademark, the protection is perpetual. That is, it is infinite, but you will have to renew it every 10 years. Okay. So why all of this is a different subject matter of discussion. Let's not bring it right here. I wanted you to have a broad idea of the major components of intellectual property. Apart from this, we also have geographical indications. These are some kind of tags that will associate a product with a particular geography. For example, if I hear Agra Peta, we remember it is the connection to the location that is Agra, and Mysore agarbatti or Mysore sandal or Hunsur teak, Coorg orange, then Chikmagalur coffee. So are we not bringing that idea of the product into the mind as soon as we hear it or connect it with a geography? That is where we provide a tag, also called as a recognition for what we call as geographical indication. Apart from all of this, we also have plant varieties, we have industrial designs, integrated circuit, traditional knowledge, and many such things. And nowadays, as I've already told you, artificial intelligence is also one domain which is popping up inside what is called as intellectual property. Hope you have understood the bird's eye view of what is intellectual property, what are the different types of intellectual property, what is the subject matter of intellectual property, what are the laws that we have. So if you've understood intellectual property, you've understood intellectual property rights, you've understood intellectual property law. Is there any doubt with respect to this?
No, madam.
All right. So now, in the first half, we understood what is cyber law, cyber crime, and other things. Now, in the second half, we have understood what is intellectual property, what are the different aspects of it. Now, let's connect both of them. As I've already told you, intellectual property talks about providing rights. Okay, how is it being recognized? By granting right, yes, and secondly, preventing any other person without permission to use that particular intellectual property. All right. So now, if somebody uses or somebody makes use of the intellectual property, be it be trademark, copyright, or patent, then we call that act as an infringement. So any unauthorized use of protected right is called as infringement. Now let's connect this infringement to cyber crimes. See, whatever the crimes that we know, if it happens over internet, we call it a cyber crime. If this infringement, whatever we referred right now with respect to patent, trademark, copyright, if it happens with the help of internet or over the internet, then we are connecting cyber crimes and intellectual property together. Let's go ahead and understand the very essence of today's lecture. So as you can see, there are different types of infringement that we can associate in the cyberspace. I've already explained what is cyberspace, therefore I'm not going to repeat the understanding with respect to cyberspace. So now what are these infringements? I have named a few, but I'll be picking up certain important things for the discussion later on. Understand, unlicensed use of marks, trade names, service marks, images, music, sound, these are the aspects of trademark and copyright where it has been used by another person in the cyberspace without express permission. That is unlicensed use. You remember, I have initially told you that who can use this intellectual property? Owner of the intellectual property or somebody who is authorized by him. Only two persons are allowed to use intellectual property that's been granted by the state. Now, if somebody uses it without any license or permission, then we call that infringement. Then apart from that, because of cyberspace, we are talking about what is called as hyperlinking, deep hyperlinking, meta tags, spamming, and other things. Let's say, for example, I want to search For example, I want to search for McDonald's. Okay, I search that in the internet search bar. So it directs me to a list of websites. Before I enter into McDonald's website, there is a sponsored link or some other link which will direct me to another McDonald's of India.com. Now, this is called as hyperlink. Probably the content is different or they're trying to do something else. So, there are many things where people try to put the consumers or the users in confusion with respect to access of such websites or the sources by creating this kind of links. Same with respect to meta tags and other things. So spamming, I've already told you that you might have received many mails from different organizations saying that you won so many crores or there is some offer for you and other things and there is instant loan, you don't have to give any documents, another thing. So this is called a spamming, where a person without your acceptance sends you any number of messages or mails which will probably affect your day-to-day life, or probably you do not want to receive them at all. So that's called spamming and the violation of digital copyrights. We will discuss them little further in a while. But this is a broad idea, and this is not something that's limited. It is the list is very exhaustive, and every day we are witnessing a very new kind of threats to intellectual property through the help of cyberspace. Let's go further. Now, as I've already told you, although we have different aspects of intellectual property, I'm just focusing on these three: patent, copyright, and trademark. Now, let us go and see what are those infringements which might happen to patent, which might happen to trademark, which might happen to copyright in cyberspace individually. Okay. Now, although when we talk about patent infringement in cyberspace, it is not so much as compared to trademark or copyright. How? See, what happens, probably today I am the inventor, or let's say I'm the researcher. Probably I would have invested a lot of my time, energy, and patience to invent something, probably some formulation that I've stored in my computer, some device, some drive. Now, because of the existence of technology of hacking, another person who is not access to or authorized to do it might hack my account, my computer, to get access to that confidential information. So this might be a problem for the innovator who is willing to get his patent done. See, once he's got the patent, anyways, the information is with the patent office, so there is nothing to worry. But probably during the phase of his creation or invention, or at the earlier stage or intermediary stage, he might be still working on it and nobody knows about it. So if someone without his permission accesses his devices or his drives by virtue of hacking, then that is infringement in the cyberspace. Theft of confidential information is also associated to hacking. So by help of these technology tools and the software tools, if a person steals any information, and for example, I am the inventor, and I had kept some formulations of my drug, which is being clearly mentioned in a document which is stored in my computer. And my computer is connected to an internet network. Probably I am connected to my work internet, which is open to common masses. Anybody from there can use that work internet and get access to my device and take the data from my device. And before I file the patent application, they go and file it. Patent office will not know whether it is genuinely done by the person or not, or it is stolen. They'll only consider who came first, if whether it is Dr. Tripura or whether it is XYZ. If XYZ came first, even though it was stolen by stolen from the computer of Dr. Tripura, but the patent office will not recognize that. It will be difficult for me also to prove that he has stolen, because of the nature, very crucial nature of the internet, which is unrecognizable, in the sense it can work anonymously. It is very difficult to find out who was the person who accessed my account. Whether it was accessed or whether it was hacked itself is a very difficult thing to determine. So these are the different offenses, or let's say infringement, that we look with respect to patent regime in the cyberspace. Hope this is clear for you. Moving further, the most interesting one, the trademark infringement in cyberspace. Please understand, I told you that a trademark is kind of a brand or a logo which can recognize a particular product to its origin or source. All right, I'll give an example. Uh, Mishra Thakur Peda. We know that Mishras are very famous for their, Thakurs are very famous for their pedas. Now, we generally, and probably they have branches in every part of the country. Yes, fine. So they are very popular. And the trademark is the Thakur's peda, which will give us a confidence that, yeah, the peda from there will be good and will be clean, hygienic, everything. Correct. Now, these people are there in the market since a very long time. But the advent of computers, internet, having a web page, website is something very new for them. Let's say tomorrow another person starts having a website called www.mishrapeda.com. Okay. Now, see, there is a different idea in law which is called as domain name. Now, what is this domain name? Just like we have address to our residential properties, similarly, we will have address to the websites. When you want to go to the website, you will put that address so that you are redirected to the address. Now, because Mr. Thakur Peda did not had that presence in the market, that is e-market or e-commerce, tomorrow anybody can register it. Again, in domain names, the idea is first come, first serve. In the sense, if I go with the request for the domain name, whatever I want to, if it is available, I can buy it from the domain name server. There is an organization called as ICANN, which will operate this. Let's not get into that. So, when I buy the domain of mishrapeda.com, probably tomorrow the original Mr. Peda want to have their website so that people from any part of the country can actually buy it, place an order, and it is shipped to them. And this is something that they want to do. But unfortunately, there is another person who is already using it as Mishra Thakur Peda, probably selling something else, or it is only to create confusion in the mind of people. Or probably again another Peda is being served there, but it is not from the authentic place. So here, the value that we are providing for a trademark should be given to domain name also. So this is what we call it as domain name dispute. This is something that is rampant these days, and there is an idea of making money out of this. Let's say, as I said, now the only solution is to complain to the respective offices, saying that the other person has actually acquired the website, but it will not take time, isn't it? So you know how what happens in the court rooms. So it will take time, and nobody wants to waste so much of time. What they'll do, they'll try to come to an amicable solution or an understanding with the person who owns the domain name, and probably say that Thakur Peda was owned by XYZ person. Now XYZ person might demand a huge hefty sum of probably 1 crore, 2 crore for letting the domain name to be owned by the actual Thakur Peda, and they have no choice. If they really wanted, they'll pay the money and get access to that particular domain. So this is one important dispute that we are seeing, which is connected to intellectual property and also cyberspace. Hope this is clear for you.
Yes,
Okay.
madam.
I can hear only one yes, but anyways, thank you. The next interesting thing is with respect to counterfeiting. Now, I wanted to buy a Louis Vuitton bag. Now, the actual price of the bag starts from about 1 lakh or something. And while I was searching, I could see some websites which can sell this Louis Vuitton bags at probably 3,000 rupees or 4,000 rupees. That will definitely shock me. Correct. Now, why will they sell a 1 lakh rupee price or more than a lakh rupee priced bag at 3,000 rupees or 500 rupees? Another thing, and there are markets like markets that are prevalent or dominantly doing this job. That's called as first copy replicas, or it is also called as replica, first copy, true copy, whatever it is called. The idea of this is called as counterfeiting. If you go to Singapore, you can get the same Louis Vuitton bag for about 500 rupees in terms of Indian rupees. Or go to Ludhiana, you have a whole bunch of market only for such kind of goods. and this is called as counterfeiting. So if I go to a real market and if I buy, then that's clear case of trademark infringement. Now, if I buy these over internet, over website, then it is infringement in cyberspace. What is the infringement? Counterfeiting. Hope this is clear for you. Next is the cyber squatting. Now, I've already explained cyber squatting. Squatting is to sit. Okay. Now, if somebody is sitting, that is sitting as a not technically sitting, is holding the right of a person's web address. For example, Raymond's. Raymond is a well-known mark. We know that one. And Raymond can also be a surname of some other person. So let's say I am Tripura Raymonds. I wanted to have a website called www.raymonds.com wherein I start selling pens or stationery materials. Now, what have I done? That although it is a common name that anybody can use it, I have sat on the website of Raymond, which is a well-known trademark, which is the actual or probably ethically, if you're talking, you should be allowed to use it, isn't it? Probably my intention is genuine. I didn't want to disturb. I didn't wanted to pass off my goods in the name of Raymond. Nobody believes that the Raymond, might sell pens and pencils also. So at times this might be intentional, at times it is unintentional. Both the case it is called as cyber squatting. If a person is sitting or holding or possessing an internet address or the email or domain name address which belongs to another well-known mark, we call it as cyber squatting. One classic example, or we also call this as a landmark case, is the Yahoo versus Akash Arora. What happened? Yahoo, you know that right now probably you might not have an Yahoo account, but initially when we started having an email account, and I think you might have heard of Yahoo as well. So Yahoo was very popular in almost every part of the world. So they had registered Yahoo trademark, and also they had website registered in their name, that is www.yahoo.com. It was registered. Okay. But what happened eventually? A person from India, that is Akash Arora, registered a domain name called yahooindia.com. So there was a confusion. People in India who wanted to search for Yahoo accidentally had to jump into Akash Arora's yahooindia.com. Again, his business was also dealing with software and other related aspects. So it was a kind of a connection for people thinking that probably this Yahoo India is also of the original Yahoo. So there was a case before the court, and finally it was held that I'll not get into what happened in arguments. It was held that just because they don't have registration for Yahoo India, it doesn't mean that you can pass off your goods in the name of Yahoo. It will cause confusion in the mind of common man, and therefore it was it was taken away from Akash Arora and given it to Yahoo. So this is one case. There was another interesting case of Google also. It's called Google Incorporation versus Mr. Racha Ravinder. Again, this fellow Racha Ravinder had registered a website called googlenetbiz.com. Although when we search for www.google.com, we are directed to Google website. In Google India, we are directed to Google. So generally, people want to have whatever the possible connections or domain names and connect it to one server or one website. Similarly, this person did register for what is called googlenetbiz.com. Again, the same thing was ruled and said that the person should not use the word Google because of the worldwide trademark that particular word has. And these are some of the examples that we know with respect to what is called as domain name disputes. Hope this is clear for you. So moving further, the last component of my discussion is the cyber infringement in cyberspace. Ma'am, I'll take another 5 minutes.
Yes, ma'am.
Yes,
Sure,
madam.
All right. So now, just like we have understood what are the different types of infringement that we can see in the cyberspace with respect to patent trademark, we also have certain things with respect to copyright. Copyright is something we should all be very careful with, because by virtue of our education in law, or by virtue of our degrees, I think we might have to submit many kind of assignments, projects, research papers, and other things. This is an area where you'll have to be cautious. Now, again, as I've already told you, that if a person is having a copyright, just a minute. if a person, I'm sorry, as I've already told you that, for example, there's a novel that is written by an author. Give me an example of an author right now. Okay, let's say the work of Kuvempu. We know that whether he wants it or not, there is copyright attached to his work. All right. So now tomorrow, if I start making use of the works of Kuvempu and translating them into English, whether am I allowed? No. If I have taken permission from the author, although he is not alive now, just giving an illustrative case, but you should understand that I was not given the permission. I was not given the permission to use it. Clear? So that is called as unauthorized use. Whether it is good for the society or whether it is helpful for them, it is immaterial. But there was no express permission from the author or his legal representatives. Therefore, such act will be called as unauthorized use. Now, what if this act happens over internet? So now, if you search probably Manupatra or any of those e-resources that we have, JSTOR, Heen Online, there are any number, many infinite number of articles and research papers that we see. And let's say I take up one research paper, I am going to use the research paper in my article or assignment eventually. Now, what am I doing? I am using the copyright of a person without his permission over internet. That is called as unauthorized use. Probably I might rightly quoting him in my paper saying that this article is taken from so and so author. So that is allowed to some extent with respect to the exceptions that we have, that is research exceptions and other things. But without that, a person is not allowed to use it, whether it is virtually or in the real world. The next important one is plagiarism, or which we are all good at. So what happens in plagiarism? We are going to use the content of someone else or the creations of another person without their express permission. Probably we might twist and turn some of the things. And now we have applications like what is it called? Spinboard or some kind of application where you just have to copy the content from the internet, put it there, and the content will be rephrased in such a way that you will not be subjected to plagiarism, but the meaning will remain. So this is the idea that we all have. But again, that's plagiarism. There is a right acquired by the owner of the copyright, isn't it? Not just his economic right, there are moral rights also. Morally, a person who has written or put his effort in writing a novel, book, or anything literary, dramatic, artistic, he also has power, or let's say he should be allowed to use it without any disturbance, isn't it? If somebody else makes unethical use of it, then that is not allowed under law. And plagiarism is also a kind of infringement that we have seen in cyberspace. Now, the most important and most happening idea or the catchword in the present domain is chat GPT. Now, what is this chat GPT? It is an AI powered technology wherein whatever we ask for, it will be done by the chat GPT. Now, how is it different from Google now or any of those kind of search engines? Now, if I want to know where is a particular restaurant located, I can search it on Google also. I'll get the proper location. But if I ask the chat GPT to write a poem for me or write a paragraph for me on so and so subject matter, chat GPT will actually do that. That is the technology that we are witnessing today. Whether it is good or not, whether it is good for the society or whether it is bad for the society is again a different subject matter. As I've already told you, it's a very subjective nature. But this is something that might also be subject to what is called as copyright infringement. If you're interested, please go ahead and know more about ChatGPT, because this is going to be the future of any of the things that we are discussing right now. So, and suddenly there is upspring of many such kind of softwares and applications that we are seeing recently, which can do everything. Let's say I want to plan a birthday party. I can just search, I can ask the chat GPT no, keep a birthday party ready or advise me for a birthday party. It will tell you everything right from having a menu to deciding the invite and everything. That is the capacity of artificial intelligence. Yes, on one hand, artificial intelligence is something that we all require to progress in a way that we can't even think of. On the other hand, it will disturb the moral values of the society and the fabric that we are all stitched in. So these are the important aspects of infringement that we will be discussing. We just discussed with respect to intellectual property in the cyberspace. And finally, now how are we going to deal with it? So there is a requirement of a combined effort with respect to social, technological, and legal efforts to combat or to defend intellectual property infringement in cyberspace. It is not happening without the coherent or combined efforts of these stakeholders. Apart from that, I would also want to conclude saying that infringement of intellectual property in cyberspace is actually very difficult to be enforced. Identification is one problem, enforcing them is also another problem. But please make a note of it, digital era challenge that we must meet in the interest of an advancement of the raising information society. Yes, it is difficult, but we can't keep ourselves shut because it is not possible. We'll have to find a solution to curb all this nuisances or the problems that we are witnessing with respect to cyberspace and intellectual property. I wish to conclude my session and thank you very much.
Thank you, madam. Now the session is open for interaction. If anybody has any question.
There are in the chat boxes, perhaps you can read them out, Pratibha.
Yes, madam. Yes, madam. I'll do that. Madam, one of the questions is, what is the role of the internet in the development, management, and commercialization of intellectual property? This is by Pradyumna.
Yes, wonderful question. See, what happens is, see, now whatever we said is with respect to infringement and other things. How are we using internet for the betterment of intellectual property is another beautiful question. That is again a positive attribute of it. So let's say, for example, if with the help of internet, what I can do is I can maintain my intellectual property portfolio. Every business will have a portfolio in a sense. The same business might have patent, copyright, trademark. With the help of internet, I'll be able to manage all of them coherently, and it is easy for me to progress further. Let's say I want to invent something. Before I invent, I'll have to make necessary searches whether there is an invention already existing of that sort, whether there is a prior art which is available. Now, how is it possible? Can I have access to everything that is there in the world, any part of the world? Now, because of internet, I can find out whether there is an invention which is similar to that in any part of the country. So that is how we can make use of internet. There are other aspects also, and commercialization is something that is very important. See, if I don't have internet, I can't sell my product. Although intellectual property do provide certain rights, but it will not help you in monetizing it. I might have an invention at hand that is protected. I can stop anybody else from using it. But how am I making money out of it? I'll have to market it. I'll have to sell it to somebody. I'll have to tell people that there exists a product like this, isn't it? How am I doing it? With having a shop in one corner of the world, will that help me? No. I require internet. I'll have to publicize myself. I'll have to have a website where I can sell my goods to anybody who is sitting in any corner of the world. That is when the idea of e-commerce will pitch in. So commercialization is this one just example. There are many other ways in which I can do that. I hope I answered your question.
Yes, ma'am. The next question is by Dr. Vidya. Her question is, when question arises with regard to curing a disease like diabetes, why can't it be brought to public domain immediately after its invention by giving royalty of 20 years in advance, as that would relate to public health?
Okay. Now what happens if you say that, okay, I have invented a drug. Tomorrow, as soon as I get the patent, tomorrow the knowledge in the public domain. So it allows anybody to make it and sell it. Automatically what happens, there will be many number of players in the market, the supply increases, price decreases, and this will demotivate the innovator. What is the point in he putting efforts for such long period, investing his time and energy to bring out a product, when anybody else without their effort tomorrow with the help of the patent protection that I have can bring out a similar drug without any effort and make money out of it? I will have no incentive at all. I will not do it further. So it is just something that nobody wants to do it. So this is the reason why I have told you to encourage the inventor so that he can invent more and he knows that he can make money out of it. And therefore, that is the reason why we are not allowing such kind of. But I'll tell you one thing: during the period of COVID, when the entire human community was at stake, there were many drugs, although which were during the under the patent regime, under the patent protection, they were allowed to be supplied in public, because when we balance them, when we put public interest and also the societal interest and one side, and the innovators interest on the other side, obviously the public interest will outweigh the innovators interest, and we have seen the cases also, but this is a general scenario.
The next question is by Chetan Kumar.
Mhm.
He asks, what is how Information Technology Act 2000 deals with the issues of cybercrimes?
I've already discussed that in the initial slide itself. It talks about what are those crimes. It talks what are those different types of enforcement agencies that they have. What are the punishments that are attached? As I told you, it clearly does not define what is cybercrime, but it will tell you that if this is a crime, this is a punishment.
Okay, ma'am. The next question is by Pradyumna. He asks, what are the distinguishing features between e-contract and e-commerce?
Okay. See, when we talk about e-commerce and e-contract, there is a synergy between them. See, e-commerce is where it's a trading place. Trading place, where is the market? The internet is the market. So let's say I am the seller, you are the buyer. Although I'm sitting here right now, I can sell my product to you. You can transfer the money, I'll ship it to your product. All of this is fine. The moment you click the buy button, there is a contract that you are entering in. Okay, there is a contract that you are entering in. So that's the reason why I told you there is nothing that is deviating from what is called as e-commerce or e-contract. E-contract can also be part of e-commerce. And whenever we talk about e-contracts, these are nothing but the agreements that are recognized by law, which will happen over internet. So generally, what happens is when you download a mobile application, you might agree the button without even reading what exactly it is saying, what is the terms and conditions. That eventually, when you click, it means that although you technically don't sign on it, or whether you use a digital signature, is immaterial. When you say I agree and say submit, it means that you are entering into a contract and you are liable to the terms and conditions of the contract that you will never read. Understood? So you understood e-contract and you understood e-commerce. At times, and most of the cases, e-contract will be a subcomponent of e-commerce.
Indrani madam is asking, what is evergreening of patent?
That's a very interesting question. I've told you that any of these intellectual property rights are limited in nature, correct? Now, patent is only for 20 years from the date of filing. Please remember, 20 years from the date of filing. What happens, as someone of you said that, why don't we allow the knowledge to be dropping into the public domain? Now, the contrasting is, if a monopolist, that is the inventor, wishes to hold the patent for 20 years, he also wants to extend it for another 20 years or probably further years. Let's not talk about how many years he wants to do it. I'll go back to the same example of my drug, which can deal diabetes and cure diabetes in a week. Okay, now I was granted patent in 2023, although I had applied for patent in 2020. My period runs from 2020 to 2040, correct? Now, after 2040, if I allow anybody to use it, then I'll have no demand for my drug. What I'll do with the same drug, with the same diabetes drug, I'll make certain changes, minute changes, which has no kind of substantial improvement in the drug. Then I'll apply for patent, I'll get patent. So eventually I'm pushing the lifespan of the patent. This is called as evergreening of patent, which is not allowed in India. The famous case which we talk about evergreening is Novartis case. There was a drug called imatinib mesylate. It was a cancer curing drug. Novartis although got a kind of evergreening patent to its crystalline form of imatinib mesylate. That is, it's a new form. Okay, the drug was already patented. What they did, the new form of the same drug was patented in many of the jurisdictions, but they could not patent in India. That was a huge news that we are probably you would have heard of it, read about it, and India did not grant patent because of Section 3 of Patent Act, which says, Section 3D of Patent Act, which clearly says that a new form of a known substance cannot be patented which is the very essence of evergreening, prohibition on evergreening of patents in India. Hope I've answered to your question.
Yes, ma'am. The next question is by Jagdish sir. He asks, X sends false information through email to his friend Y to cause annoyance. What kind of offense X committed under IT Act?
Now sending information, false, what is it? False information or message or any pictures?
False information through email to his friend.
See,
To
please
cause
understand.
Yeah.
Now, this friend is a known person. It depends on what the other person is pursuing. Let's say he sends false information about some of the relationships or something. Then he is doing what is called as it's not even identity theft. Again, it can be covered under any of the IPC acts where it is not genuine. The same thing which is happening in cyber, that's called defamation. Now, this defamation happened over internet, which is not true. Correct? So, any crime that we have spoken under IPC, which happens over internet, the same subject matter applies, but it is again protected because of the virtue of Information Technology Act.
Ma'am, I think that's about the questions in the chat box. I think we are done with the questions. Indrani Madam is asking if you can provide a case law for evergreen patenting.
I just mentioned Novartis AG versus Union of India.
Okay, ma'am, that's it.
It's a landmark case. I think you should never forget this case because of the higher amount of importance given to this case, because the developed nations like US, Switzerland can easily give patent to such an evergreening kind of a patent, but India, although developing, but it stuck to the objectives of the patent law and also intellectual property regime, and therefore it's been criticized elsewhere, but that's fine. India stood for the objective of the intellectual property law.
Thank you, madam. To conclude, now we have the vote of thanks by Nandini from 9SEM, BCom LLB. Nandini?
Yes, ma'am.
Yeah.
We are immensely grateful to Madam Tripura V, Assistant Professor, for delivering an insight on cyber intellectual property law. I also specially thank Miss Indrani S, Principal Bishop Cotton Christian Women's Law College, Mangaluru, Shri Chetan Kumar TM, Assistant Professor, RN Law College, Belagavi, Miss Purnima D, Advocate Supreme Court, Dr. Vidya Setam Nawar, Assistant Professor, KPEC Law College, Dharwad, Dr. Savita Patel, Assistant Professor, Hurakadli, Ajja Law College, Dharwad, Dr. Ramesh R, Assistant Professor, Vidyodaya Law College, Tumukur, and Principal of SCAB Law College, Raichur, for being a part of the webinar. Tripura ma'am, it has been a pleasure to listen to you and understand the nuances of cyber intellectual property law. On behalf of Vivekananda College of Law and all the participants, I express profound gratitude to you, ma'am. Thank you.
Thank you very much for this opportunity. I thank my senior as well as my close friend Bhuvaneshwari ma'am for this wonderful session. Thank you so much, ma'am.
Thank you, Tripura, for
Thank you,
accepting
madam.
our invitation and delivering an enlightening lecture. Thank you so much.
Thank you. Thank you, ma'am.
Thank you, Tripura, madam.
Thank you.
Can we